So, hi everyone. Good evening. It's great to see lots of you back after we've been through this long day of work in our international workshop on big data and data protection. For those who are coming from outside the strange world of our seminar, welcome as well to the ITS. So this is part of our Varanda series. Varandas is balcony in Portuguese. As you probably can see, we're not in the veranda, we're not in the balcony because of the weather today. It's quite unfortunate, but I will definitely compensate that with a very good and a very interesting conversation that we are going to have with Professor David Stewart in this evening. So just for quick introductions, Professor David Stewart is a professor at Georgetown Law School and is responsible for the principles on data protection from the Organization of the American States, and is going to present a little bit about the principles and then engage in a discussion around privacy and data protection. So professor is going to speak for 20-25 minutes, and right after that we open up for questions and comments from the audience. So let's make it an informal conversation. And we have drinks, we have food, so we would advise you to get a food and get some drinks, and while we get the conversation going, okay? So with further belongings, let me pass the mic to Professor David Stewart. It's a pleasure to have you here in the ITS, so thanks for that.
Thank you very much, and it's a great pleasure to be here. Thank you, everybody, for coming. I thought what I would do is share with you first some comments on the Inter-American Juridical Committee, because it's probably not a well-known institution, but it is a unique one, and it offers some special opportunities for those of us who are interested in the development and harmonization, certainly the promotion of international law. I'd like to spend just a few minutes acquainting you with the structure and the nature of the committee, and then I want to turn to the draft principles on, well, they're no longer draft, they are the OAS principles on data protection and privacy. And then I would like to hear your questions and comments. We're passing around some copies. I'm afraid we don't have enough of the volume, the printed copies for everyone, but I hope you will take a moment to look at them if you haven't already done so. And I'd be very pleased if at the end we do have some questions and comments, because it's much more entertaining, at least for me, to hear what you have to say than to talk at you. So to begin, the Inter-American Juridical Committee is the legal consultative body of the OAS, the Organization of American States. It focuses primarily on issues of international law. It's a century old. In fact, it goes back well before the founding of the OAS itself, but is today rooted in the charter of the organization. So we actually have a formal mandate and have a place in the structure of the OAS itself. We're only 11 members. As a legal consultative body, we have a function somewhat similar to the International Law Commission in the UN, but we are much smaller, and we have a very different mandate in the sense that the International Law Commission takes on very large and complicated topics of international law and often study them, drafting articles or drafting texts on some occasions for over a decade or even 2 or more than 25 years. We tend to operate much more quickly and often produce things within a year or 2, even though we are smaller. We are headquartered here in Rio at the Palace Itamaraty, supported in Washington by the Department of International Law, but here in Rio by Christian Perron, who is the representative chief of the office here and minds things when the committee isn't here. We meet twice a year, usually once in Rio and once somewhere else in the hemisphere by invitation. If we don't get a good invitation, we come back to Rio, which is a good opportunity. And our meetings are relatively short, sometimes just a week, sometimes 10 days, compared to the 3 months that the International Law Commission typically meets. So very different bodies. We call ourselves cousins. I often call us country cousins, the poor relatives from the out back. Our purpose is not only to advise the OAS and the General Assembly, but also to promote the harmonization and codification of international law. So our mandate is in part given to us by the General Assembly, and in part we get to choose things that we want to do. You can guess which one we think is more fun and more productive often, but we have to do what the member states tell us to do. And our agenda is quite a broad one as a result. Sometimes we get tasked by the General Assembly to consider very broad and important topics, and sometimes very, very narrow topics. But for example, in recent years, we have responded to requests having to do with the nature and content of representative democracy in the hemisphere. That's a topic that my daughter would say is like important. We say, yes, it is. Thank you very much. And other things such as asylum and refugee law and immigration issues, which often are very important in our hemisphere. While we're not the primary institution in the Organization on Human Rights, we often do take up some human rights issues. For example, the OAS General Assembly asked us recently if we thought there was a need for a new international instrument proclaiming the rights of people who are, let's see, LBGD. Yeah, and we thought about this for a minute and said, well, you know, the Inter-American, the American Declaration on Human Rights says, let's see, all people have a right not to be discriminated. The American Convention says all people. Takes a lot of intellectual firepower to decide that all people probably includes everybody. And therefore, we wrote back and said, no, we don't think so. Well, I don't know if they were happy with that answer, but I thought it was a good one. We've taken up recently the issue of corporate social responsibility and produced what I think is an excellent report on developments in the hemisphere in that field. We're currently looking at issues of state immunity, and we did one recently on freedom of expression. You can get the idea that our mandate often is quite broad. We have a long tradition of focusing on issues of private international law, and this goes back to, it's a tradition within our hemisphere, of course, going back to the Bustamante Code in 1928. But we've adopted, the Inter-American Juridical Committee over the years have adopted quite a number of formal conventions, treaties, in the area of private international law, going from everything from the rules having to do with service of process in litigation to enforcement of judgments to proof of foreign law, rather difficult technical topics that make lawyers excited and that other people think are very boring. And most of the time those conventions are adopted through a process known as the Specialized Conferences on Private International Law, and they're usually referred to by the acronym in Spanish. We just say CIDIP. I couldn't tell you the full Spanish title, Christian can, but anyway, CIDIPs. Good. So these are formal diplomatic conferences in which all the member states get together and they decide on the text of a treaty. Over the course of history, it's been somewhere close to 30 such treaties. Very important. But recently, the attraction of states to join formal treaties has subsided. They're not. It seems very interested now in adopting formal treaties. Many of the treaties that were adopted a few years ago have attracted very few member states. As a result, there are other factors as well. We've tended to move to what we call soft law instruments, such as statements of principle, model laws, guidelines, and other things which don't require affirmative action approval by the states, but are offered for their endorsement and acceptance and implementation. And so by way of illustration, we recently did a very important topic, model law on secured transactions in our hemisphere. That's a topic that lawyers love and other people don't, but it has to do primarily with promoting effective commercial transactions. It's been quite successful as a model law, probably much more successful than a formal treaty would be. We recently did a model law on the rules of incorporating what we call small and micro businesses and corporations in order to facilitate the rules that have to do with businesses forming corporations, limited liability, getting government approval, and so on. We recently did a model law on the protection of cultural property in times of armed conflict, and a few other things. And these model laws, these soft law instruments, can be done more quickly and often have more effect in practice than the formal treaties. So there's been a shift in the approach. And I give all of this to you by way of background because the topic we're going to talk about is, in fact, such a soft law instrument. It's the set of principles of guidance, of legislative guidance in the area of data protection and privacy, and it was done in that form precisely because we didn't think that it was a good time, a good opportunity to try to address these issues in the formal sense of a treaty, and that treaty would be very difficult to negotiate and might not attract a lot of states. So there's a purpose there. The only other thing two other things I want to say about the committee is that we do coordinate our work gently, and we consult with other bodies in the world that work on private international law, such as the UN Commission on International Trade Law, the Hague Conference on Private International Law, an institution called UNIDROIT in Rome that focuses primarily on commercial and financial law, and some others within the International Law Commission to an extent, but also with bodies within the European Union and the African Union. We consult with them on a yearly basis. And the idea is economy of purpose. We don't want to duplicate things that are being done in other fora around the world. It turns out that private international law is actually a very big field, and there's lots of activities. And it is important for us to focus on it, I think, because it has to do primarily with issues of economic development and promotion of the rule of law. Most of the time, international lawyers think of the very big issues of war and peace, of the United Nations, of the use of force, rules of jurisdiction in international disputes, about the World Court, and so on. Our mandate, as you'll see from the examples that I gave you, is quite different. We tend to focus on issues that are of practical importance, and if resolved, are of a practical benefit to the citizens in our hemisphere, that help to promote the rule of law and economic development in our countries. So we don't spend 25 years thinking about articles of a treaty on state responsibility, but rather how can we help the small and micro businesses become incorporated effectively, because we think that's important. Well, that's all by way of background to introduce you to the Inter-American Juridical Committee. I'll just spend just a few more minutes talking about our future agenda, and then I want to turn to the question of that I think we came to discuss, which is privacy and data protection. This year, we adopted a report on border integration zones, which is an important issue. But on the docket for future consideration is a product that, again, only a lawyer could really enjoy. Maybe some of you will. Electronic warehouse receipts. And it sounds very exotic, but let me give you an example. It may not be true so much here in Brazil, but I say to my colleagues in Washington, if you go out to buy some fruit or some flowers at the local shop, where do you think they come from? And usually the answer, it takes a little coaching, but the answer is, well, they came from somewhere in Central or South America on the plane overnight. And in many cases, they were grown on a rather small farm by a rather small operation, a few people. And they were collected and taken down to a collection point, a warehouse or something else, and bundled with some other products, and then they were taken to another point, and eventually sequence, they're put in one of those big containers and put on the airplane and overnight to Miami or to New York, and then they're distributed again. And that's very good, and it's very nice, and we get fresh flowers and fresh food. But the question is, what about the person, the people who grew that product, who took the work? When did they get their money? Did they get it when they, thank you very much, when they turn the flowers in? Well, probably not, because they have to wait for the purchaser to buy the product, and then the money comes flowing back down the chain. And lawyers would call this then it's a transaction. It would be in the form of a warehouse, a bailment. You give it to the warehouse owner, and then he passes it along, and you get a piece of paper that says, yes, you gave me the flowers, and you have an interest eventually in getting the money. This isn't very good for the farmer, the grower. If, on the other hand, you had a standardized system of warehouse receipts that all the warehouses used, and it was electronic, it went through the computers, and it was what the lawyers call negotiable. That is, it evidenced a secured interest in the funds, and the farmer could give in the product, get back in the truck, go to the bank, and say, in exchange for this note, this secured interest, this electronic warehouse receipt, I want some money. And the bank would say, okay, that's a valid document. Here's money. You will buy some more seeds or whatever you need. That might actually be productive. It sounds very simple. It's actually a very complex problem because the system in different countries works entirely differently. This is the case in the United States. We've been trying to sort this out for over a century in the United States and still working on it. The World Bank has projects of this sort in Africa and around, and we thought perhaps in the area of agricultural products in our hemisphere there would be an area of progress to be made. So we've done about a year's work on that, and we have to stand back and say this is actually harder than it sounds. We thought this would be an easy one. And it turns out to be more difficult. So we have to stop and think it through and sort it out. It has to do with the technicalities of warehousing law, of growers' bailments, and so on. And it's going to take some reform. We'll continue to do that. I think that's an important topic, but it illustrates the kind of thing that we're interested in. We're also working on an issue of human rights, which involves the status of human rights treaties in domestic law, and in particular, what effect is given in our hemisphere, in the Inter-American human rights system, to the decisions of human rights courts and bodies. If you have a decision from the court in San Jose, what status does that have in the Brazilian courts, for example? There have been some very recent developments in this. For example, the Mexican judicial system has decreed that decisions of the court in San Jose are effective Mexican law at all courts of all levels of the Mexican court system. This is rather revolutionary. It would get the folks in the United States Congress rather excited if we raised this question with them. But again, it has some real possibility for benefits in the system. Well, that's just a few of the topics that we're looking forward to. Let me turn now to the question of data protection, and then I want to open it up for discussion. For those of you who heard my earlier intervention on this question, I made the point that our legislative guide, which contains principles on data protection and privacy and a set of suggestive policy considerations for people who are thinking about adopting these principles or adopting a law based on the principles, that this is a very particular document adopted for a very particular circumstance. It is not intended to be the complete manual on data protection or privacy. It's not intended to be a model law. It's not intended, for example, for the Brazilian legislature or for any other country in the hemisphere that has already given a lot of thought to how to handle questions of data protection and privacy in the hemisphere. We recognized, looking at this problem, that there were different levels of consideration, different levels of sophistication within the various countries in the OEA. Some are quite advanced, have been talking about and considering this problem for many years. and some have done very little, if anything. It's that second group that we were addressing. And we thought, how could we make the most effective contribution? And the model is to think about a legislator or an assistant to a legislator in a parliament, in a Congress, in the legislature, who really knows very little about the issues that many of you are quite sophisticated in. I know it's shocking to think that legislators don't know what we know, but that's certainly been my experience in our own government. And we thought, how could we help? And we thought the best thing that we could do, and actually we were asked to do this by the General Assembly of the OAS, is to write a very simple, straightforward set of guidelines for the person who knows relatively little, saying, as you consider these issues, here are some things to think about. We didn't provide a model law. The OAS General Assembly had suggested that we do this through a model law. And we thought about that and said, well, a model law isn't going to have any effect on Brazil or Mexico or any of the countries that have already thought about it. They have a statute. It's going to be irrelevant. And for those countries that haven't gotten one, they're probably not going to be particularly attracted just to take it off the shelf. They're going to want to think about it. So we said thank you to the General Assembly. On consideration, we think a set of principles that is fairly general, fairly simple, but highlights the most important issues. That's probably going to have the most effect. I think that will be true. We don't know yet exactly what effect they will have. But in any event, that's the nature of the instrument. It's not intended to be the complete treatise on privacy. It's not intended to answer all of the issues. It's not intended to accommodate all the differences in our hemisphere. It's intended at a level of generality to get people started on the right foot, on the right way to think about these things and leave them the room to make their own choices as appropriate to their domestic systems. So we came up with 12 principles, and they are based on, drawn from, existing international instruments, those in Europe, the Council of Europe, the European Union, those in other legal systems, the African Asian Consultative Committee, for example. They are drawn from the human rights treaties at the international level. They're particularly based on the American Declaration of Human Rights and our own, the American Convention on Human Rights. And they're intended to reflect generally accepted, we might even say globally accepted, principles of privacy, and coupled with evolving principles of proper consideration of data protection statutes. So the 12 principles are fairly simple. I won't take your time to read them all, but let me run through them very quickly. The first three have to do with the vital question of what rules apply when a business or a government collects information about people. And I should say these principles are written both for governments and for corporations, for private businesses. That makes it a little bit more difficult and perhaps more important that they're done at a general level. So, for example, the first principle says, in effect, that when data is collected, it has to be collected only for lawful purposes and only in a fair and lawful manner. That's hard to argue with, but in practice, that's not always the case. And we give a little bit of discussion about what those terms mean. What does it mean to say lawfully, and what does it mean to say that information can only be collected by fair and lawful means? And for some people, these are not self-evident terms. The second principle builds on that, and it says that the purposes for which personal data is collected should be specified at the time of collection and should, in principle, personal data should only be collected with the consent of the individual. These two joined principles, that is, disclosing the purpose at the moment of collection and obtaining the consent, seem to us to be the bedrock of a good approach to data collection involving personal information. There's a lot of difficult issues packaged within those terms. For example, how transparent? When we say that purposes must be disclosed, how transparent do those purposes have to be made? And when we say they have to be collected in principle with consent, does that mean it's possible that information about us could be collected without our consent? In consulting with not only governments and NGOs, but also corporations, we realized that in fact, yes, there are times when information is collected about us, and it's simply not at all practical to require us to provide our consent. Sometimes consent can be inferred, but there are other times when it's just not possible to get the individual consent. This rather surprised me as I talked to people who are engaged in this, but I became convinced, as others have, that it's necessary to use a rule of reason. And the third basic principle at the stage of collection is an obvious one, I think. The data collected about us should be accurate, relevant, and necessary to the purpose for which that data is collected. That seems to be a bedrock principle that is recognized in all appropriate sets of principles and guidance. The next 5 principles have to do with the rules that govern the retention and use of the information once it's been collected. And very quickly, they are simply that the information that is collected should be kept and used only for the purposes for which it was collected, or at least in a manner that isn't incompatible with the purpose that was given to us when it was collected. And it shouldn't be kept any longer than is necessary for that purpose. So those are important. The 5th principle imposes a duty of confidentiality when personal information is collected. It shouldn't be disclosed, made available, or used for purposes other than those for which it was collected, except with our knowledge and consent, or under the authority of law. So we can't be told it's going to be used for purpose X and then it's used for purpose Y unless we have an opportunity to contest that. The 6th principle says personal data has to be protected by reasonable and appropriate safeguards against unauthorized access, loss, destruction, use, modification, or other things. Here we had a separate paragraph on the growing problem of data breaches when the data collector, data processor, has its storage facility, the storage mechanisms hacked, and suddenly you find out, as often is now the case, that a store's computers have been hacked and our personal information has been stolen, in effect. They have to tell us that, and there has to be legal mechanisms for trying to contain the damage. The 6th principle says that simply that personal data should be protected by reasonable and appropriate safeguards against unauthorized use. Well, that's the one I just read, sorry. It's important enough that we should say it twice. So I think we're now up to the 7th principle. That principle says that information should be kept accurate and up to date. And the 8th principle says that as data subjects, we have a right to access the information that is kept about us and to try to correct that information if there's something wrong, to correct any errors or to seek the deletion of that data if it's in error. It turns out here again that a rule of reason is the right approach, because there are some circumstances in which it's simply not possible or practical for the data, the outfit that has your data or is processing it to find out all the information and the accuracy, or to make all the changes. So we didn't say it's an absolute right, but rather one that's governed by a reasonable expectation. But if that your request is denied, you have a right to find out why it's been denied, and you might have a right of, let's say, judicial redress in the occasion if you thought it was wrong. Difficult area here is the right to be forgotten. We've called it the right to correct errors and omissions. It's a right of rectification. Not everybody agrees with the current formulation in the European context about the right to be forgotten. We had to look at this from a hemispheric point of view, and there are substantial differences in the various approaches in our countries within the hemisphere. We have quite a number of countries, and they have different approaches to this. Some have a right of habeas data. Some have a right to be forgotten, a right to eliminate data if you don't like it, as in the case of, let's say, the Google Spain decision, but others do not. So we had to note that issue, but we didn't have a requirement on it. So that set of principles cover the retention and use and correction of data. The ninth principle talks in particular about a category of data called sensitive personal data. And this is information which, because of the context in which it's gathered and the context in which it might be used or disclosed, presents specific problems. And it turns out sensitive personal data, what might be about our sexual preferences, our political preferences, our religious preferences, this varies from system to system. What's sensitive in one system might be utterly non-controversial, non-dangerous in another system. So we made the point that says whoever is looking at this, adopting the law, has to take into account the context in which this comes. You can't tell everybody exactly what's sensitive in what circumstances, but that's for the authorities to consider. So those are 9 operative principles. Now the 10th one is vitally important. We're almost finished. We call this accountability. Data controllers should adopt and implement appropriate procedures to demonstrate their accountability for compliance with these principles. What do we mean by that? Well, the data controller is whoever has control of the data. It could be a business, it could be a government. We were really addressing the private side of the house because there are some other rules for governmental entities, but the principle should apply to both. And in the case of data controllers that are private, this principle reflects the idea that they have an independent responsibility. They must assume responsibility for giving effect to these principles. It's not simply the role of the government to say, you must do this. We think it's more effective to put the onus on the company, the processor, and so on, and say, you have an affirmative obligation to do whatever is necessary to show that you're going to comply with this. You have to have some kind of compliance program, for example, to show that you are, in fact, accountable. We talk a little bit about the notion of privacy by design and about sharing data with other parties. But I think this is a fundamental aspect of our approach, saying that it's not simply a matter for the government, it's a matter for the institution, the private entity as well. The 11th principle is also important, and that talks about transborder flow of data and accountability. This is one of the most controversial areas, precisely because our countries, not only in our hemisphere, but if you look across the oceans to Europe and to Asia, we have different rules. As we all know from reading the newspapers and from the Schrems case, there are often different approaches, and the question comes up, well, if you have data in one country and you're sending it to another, do the rules, the responsibilities of the sending country or the receiving country apply? What we said here was you have to take into account 2 things. 1, protection of data, and 2, the individual's right to free flow of information, and 3, our general interest in trade, development, rule of law, but economic development. And if you cut off the flow of data, you are inevitably cutting off the engine of economic development in many cases. We don't take a firm position on how this is to be resolved, but we were essentially saying to the legislators, think hard about this issue because it has implications beyond the question of the simple question of data. We can go more into that principle if you like, but it's an important one. So we talk about data flows and national restrictions having to do with differing levels of protection and prospects for international cooperation in that area. This is probably the most difficult area of all, given the current state of play. The final and 12th principle is fairly easy. There are cases in which governments have to make exceptions to these rules. They might be national security, they might be law enforcement, there could be other things. We don't purport to validate any particular form of exception, but what we did say was if you're going to make, if the national authorities are going to make exceptions for reasons relating, for example, to national sovereignty, internal or external security, the fight against criminality, regulatory compliance, or other public order policies, they have to make those exceptions known to the public, and that seems to be the best way to hold the governments accountable, to let people know what's going on, and to have a debate in a formal democratic system. So those are the 12 principles. They have yet to be adopted by the General Assembly, not because the General Assembly doesn't like them, I hope, but rather that the last time it met, it was focused on other things and didn't consider them. So we hope that perhaps in the next year we'll have them formally adopted. Meanwhile, we didn't wait. We have great respect for the General Assembly, but we went ahead and published them. You have the book. And we hope that they get circulation and that they become part of the dialogue because, again, that's the purpose of them, to try to give a hemispheric approach. And the final thing I want to say is this is naturally at a level that addresses issues that are common to, we think are common to all our countries, a level above the details in which they differ. And specifically for those legislative bodies or advocacy groups that are trying to get that discussion going on a proper basis in a given country, we hope they're helpful. I imagine that many of you have comments about the details of the principles. I'm happy to respond to those or to any questions you have about the Inter-American Committee. But let me conclude by saying that I think there's something rather unique and important about the Inter-American Juridical Committee. It's not the kind of body that you find in many international organizations. Hard to find one, for example, at the global level in the United Nations. It has the potential to make very important and concrete contributions to legal developments in our hemisphere. That's at least what we like to think. We're not experts in many of these areas, so we're not going to be writing the perfect document, but we try to add in a helpful way to the conversation, and we hope that our products do, in fact, get some use and application, whether it be for fresh flowers or fruit, or for the rights of individuals in a human rights context, or for data protection and principles. So the advertisement at the end of this discussion is simply that if you think there might be a role that you think the committee might play, Christian is the guy to go to and to say, would it be possible for the committee to think about that? We like to address new and interesting issues and to see if we can play a positive role. So thank you very much for listening to this, and I would be happy to take any questions that you have.
Thank you, Professor. Just me. So thank you, Professor. It was great hearing about the principles. And now comes the time that we can comment, ask questions, and reflect a little bit on the issues that Professor David has mentioned. So please.
Thank you, Professor. It's a really comprehensive principle framework. I have two points to make. The first one is, how about the right to anonymity and encryption? Is it somehow covered in any principles here? And second is, regarding ninth principle, sensitive personal data. I have a bit reservation to the word of sensitive, because sensitive is, we don't have an international standard about the definition about what is sensitive. So I'm not sure if sensitive can be interpreted differently in different cultural context. So I wonder if that's the case here, because in our experience that we ever worked with ITU on the treaty on the telecommunication, and some members that they want to say some sensitive information should be blocked. We found sensitive can be quite negative, because it's they can really have there's so much liberty to interpret it by the states.
Should we take a second question, or?
Okay, if I can remember those two.
What do you prefer? Okay. Yeah, so you see? So let's go pair by pair, okay? So.
Just a quick question, just to compare what you were saying this morning and what you are saying now. You were saying this morning that when it comes to privacy, coming to a consensus on what that means and implies in terms of protection was quite difficult at the international level. And now you are telling us that we have a global consensus of key definitions and principles. So I just...
Okay, that's a good question. Thank you. Both are good questions. On the issue of anonymization and encryption, no? Okay.
This one is better.
If I use this one, I'll sound like you.
Yeah.
On the question
Switch
of encryption,
Anonymity.
sorry, anonymity and encryption, we did mention anonymization, but not in any detail. And we did not get into encryption because that was at a level of detail that we thought our target audience, the legislator, the assistant legislator, that's a kind of an operational issue that would be very difficult. We wanted to keep these fairly short and general. So no, we did not get into that issue. Well, I mean, it poses, that's a longer discussion is what I'm saying to deal with that effectively than we wanted to give. The second question that you raised on sensitive personal data, again, our feeling was that you could try a definition of sensitive personal data, but it wouldn't be quite the same in different countries. We looked at how that issue is dealt with in other instruments at the international level and came away with the impression we were better saying that there is such a category, but it really depends on the context. Let's take an example. I think it's probably true even in our hemisphere, let's just take the American hemisphere, that membership in a labor organization in some countries doesn't matter. In other countries could be a very difficult, potentially threatening situation. So how do you deal with that? Can you say, did we have to list all the things that might possibly be dangerous? Sexual orientation or religion or political affiliation in some cases pose no problems. And in others they might. And in any given country that might change in the course of a decade. So that's an issue for legislators to consider on a national basis and maybe even for whatever authorities implement this. On the other question about privacy, I probably wasn't clear enough. I do believe that there is no international consensus on exactly what privacy means. There is a fairly clear basis in the law in our own hemisphere for making some general statements about privacy, and we've done that. In the materials, you'll see we actually do quote from the American Declaration and the Inter-American Convention, and a case from the Inter-American Court, for example, to look at the American hemisphere, but at a general level. And so my point still stands. I think at a general level we can say there are notions of privacy. If you read the document with some care, you'll see we fudged a few questions because some countries in our hemisphere talk about the right of personality. Others don't recognize that right at all. So even in our hemisphere there are differences. We tried to keep it at a level above those differences in order to speak to the entire hemisphere, however it might be useful. Does that explain the approach? Well, those are two different things, yes.
And this is more about...
It's about both. Okay, yeah. Again, we had to deal with some difficult issues. We could have taken 5 years and written the book. Some of you would still not have liked the book. But we thought that having a more general statement that was useful, could be handed out more quickly, might have more of an impact even though it wasn't the perfect document. It's a judgment.
Let me give you a fact pattern. Let's take telephone call detail records that we use on our mobile phones. The metadata, who called whom, when, from what place. And we remove all the personally identifiable information. We aggregate 1 million or 10 million or 15 million of these. Do your principles of purpose specification and consent apply? And because they will be used for traffic management or disease propagation or something completely different from the original purpose of collection. But if all the identifying information has been stripped out, would your purpose specification and consent rules still apply?
Well, we tried to write the principles in a way that, yes, they would be broadly applicable, but they won't give you the answer in a specific case like that. We understand the problem, of course, about aggregating data and about the attempt at anonymization. Let me see if the example that comes to mind from my own system has to do with zip codes. I'm sure that in Brazil you have postal codes. If I understand our system correctly, if you associate an individual with his or her mailing code, you narrow the data set down to about 30,000 people. That's the average number. A zip.
9 digits.
Hmm?
On the 9 digits.
On the well, I think we're just dealing with the 5. Yeah. If you go to the 9, it's much smaller. If you then add in the gender, male or female, you drop it to something like 90 people. If you then add in birth date, you're almost there. And then you can add in any other identifying information. So we recognize the problem of aggregate data and anonymized, I can't say the word, data, but it's easy enough to disaggregate. And there's so many different situations, we couldn't come up with a rule that would provide it. We think that that's a level of detail that has to be discussed at the national level, however folks want to do it. We're not in a position to prescribe exactly what happens, but the principles would be applicable in general, yeah.
But as it stands, purpose, we'd have to say this is going to be used for propagation of dengue fever, and please give consent for that.
Well, no. As I said before, there are situations in which the concept of consent is not functional. And we do say that. There are times when consent can be inferred, and there are times when consent just isn't relevant. I hope you'll agree with that if we don't have to agree with which situations fall into which category, but as a general matter. Yes, ma'am.
First of all, I'd like to thank you again for a very nice presentation. I have to say I got a bit more optimistic now in the afternoon than I was in the morning, because I had the impression that the principles that you thought about could be thought in the same way that we have in the European context, that you kind of respect the margin of appreciation of the states, but you agree with the minimum standards. And I think this is good. It's a step forward, and I really think it's a nice initiative. And I would like to ask, what's your impression regarding the space that there is in the OES to discuss this, something in the same terms regarding internet rights, like translation of the application of human rights to the internet, let's say net neutrality, or in the same way that we have the Internet Bill of Rights here in Brazil and the Italian Parliament now?
Well, first of all, thank you for thanking us. And we don't use the term margin of appreciation. We're kind of talking along those lines, certainly recognizing that different governments within our hemisphere may reach different results, different policy options, and we're not the ones to tell them do this but don't do that. In the EU, the authorities can do that. They have that legal authority, but certainly in the OAS it's not true. So if we were to say margin of appreciation, it would be with capitals and underlined and exclamation points, but that's not a term that is ordinarily used. The second question was, your comment was about this. Yeah, it's a difficult question. I think my answer is I probably the committee would be willing to give some thought to whether there's something useful that could be done. I don't have a strong feeling because I don't understand the issues well enough at this point to know whether it's worth taking up the time, but it's certainly something that we could think about. It's a complicated issue. I had, coming into this meeting, some thought that maybe there was something to do that we could usefully contribute in the area of big data, but after the discussion in the last 2 days, I'm very happy to leave that issue to you experts. It's a very, very complicated issue, and it needs more thought. My own vote would be our particular 11-member group probably at this point doesn't have much to contribute in the discussion as I've understood it. It's much more technical. So we do try to make a decision about what we can do usefully and what ought to be left to other bodies. For example, in the area of human rights, we often say that's really something for the human rights specialists, not for us. Other questions, comments? Yes, sir.
Firstly, good evening. Well, my question comes from a personal experience I've just had. Today, in Brazil, we are having a huge controversy with regards to international cooperation between Brazil and the US. Specifically, the case of Facebook and Google. If a criminal judge today wants to have access to the transcripts and the records of the conversations, the private conversations in Facebook or in emails, he can require Facebook or Google to send those information, but Google and Facebook are refusing to give that information to a Brazilian judge, and they raise in their defense the argument that they have to obey to the MLAT, I don't know if that's the name in English.
Yes, that's right.
The convention between Brazil and the U.S.
Yeah.
that the procedure should be a regulatory letter. So I really would like to hear your opinion about that, and if this is the right procedure, or if maybe Brazil could really enforce this measure and really get access to this
Okay.
information.
So this is a case involving a Brazilian judge that is trying to require the information to come from the U.S., or is it a U.S. judge requiring?
No, just a Brazilian judge wants to get access to a transcript of a conversation between two Brazilians, and the Facebook says that he can't give this information because this information is not in Brazil. This information is hosted outside Brazil.
Yeah, yeah. We actually talked about this case, or one related to it, earlier in today, the Microsoft case, which is pending now in the appellate court in New York. And it's somewhat the same. It's a case involving a U.S. government search warrant, criminal search warrant, issued to Microsoft, which is in the United States, for email data which is on a server in Dublin, Ireland. And the government says because Microsoft is in the United States, we can force it to give that information, even cough it up, because they can access it from the United States. The Irish don't need to do anything. And Microsoft says you can't do that because your search warrant doesn't apply extraterritorially. And at one point they were talking about the MLAT. I'm not sure that it's still an active issue. Mutual legal assistance treaties are designed to overcome exactly these problems. They are mutually agreed mechanisms by which the law enforcement authorities in one country can make requests of the law enforcement authorities of another country in order to get evidence in a criminal proceeding in a way that's admissible in court. Each of our systems has different rules on evidence that can be, and how evidence is given in court. So the MLAT is a mechanism for saying, I need this information from you in this certain form with this affidavit and so on. So they're designed precisely to overcome these kinds of issues. The problem is they are direct between law enforcement authorities. They don't go before a judge. So that's part of the dispute. My own feeling is that in this case, the MLAT would be the better way to go. Because it is the agreed mechanism, and they're designed to give the authorities in each country an option to say, no, we can't do that under our law, or we won't for these reasons.
But we find a real problem regarding the MLAT, because the procedure they give us takes too long, and in a criminal investigation, you just can't wait all the time that...
Yeah.
So
this issue has already also come up in the Microsoft case. I used to negotiate MLATs in one point, and one of the very reasons for them is to get information quickly. It's quite possible to provide the information quickly if you want to do it. but if the government doesn't want to do it, it's going to take a long time. So I don't know the circumstances of this, but as an international lawyer, having done this, the purpose of an MLAT is to overcome these problems and get this problem resolved on a consensual basis. Courts have to respond to their own national authorities. They have to respond to their own law. They're guided by their own law. I personally think that courts are in a difficult situation when you ask them to balance the respective interests of two countries and law enforcement and to decide these things. Most judges would say, look, that's not my job. I have to apply the law to the case in front of me. Now you're asking me to assess the interests of Brazil or the interests of the United States and make what's essentially a political or foreign relations decision. That's not something I'm comfortable doing. The MLATs are designed in part to overcome that. I hope that's part of an answer. But as a former government attorney, I'd rather see these things worked out on an agreed basis than to have these confrontations, because it's very difficult. And
This is actually in our Supreme Court now.
That's very
It is
interesting.
yet to be judged
Excellent.
by our
Okay.
Supreme Court.
Okay.
And our
Wow.
general attorney, I think the general attorney or prosecutor, I'm not sure, he gave an opinion, and he said that Brazil should not apply to the MLAT in this case.
Very interesting.
His opinion is that if you are in Brazil, if you agreed to come to our market, you have to obey
Yeah.
to our rules.
Yeah.
If there are two Brazilian people dealing and this information is a criminal matter, the Brazilian government ought to have access to that information because it's
Okay.
internal corporis act.
Understood. Yeah. Very interesting. Well, I think Microsoft is going to our Supreme Court. You'll have one in your Supreme Court. We should get together and write a law journal article about this. It would be very interesting. Is that a deal? Good. Other questions? Thank you.
No, it's just a quick question. I've read quite a bit about people discussing the principles, and one of the things I've heard a few times, more than once, and we've kind of heard in the morning as well, is that there are two ways to build an international international consensus, run to the bottom or run to the top. And some people consider this principles run to the bottom. And I disagree with them. I think there is a basis in order for each country to build on, but I want to know what would be your answer to this particular criticism.
If we knew all the answers and could write them down, if we could run to the top and we'd get it all correct and wouldn't have to worry about this any further, then I would say that would be the way to go. But I don't know where the top is, and I don't know anybody who knows where the top is right now. So yes, these are done at a much lower level, in part because that's where we think we can make the contribution. And our target audience is not those people that have been arguing about how their laws should be accommodate all these interests for several years. They don't need our help. It's the ones that have yet to really address it, where we thought, good idea to get the basic principles, starting point for them, and say, pay attention to these principles, and then you can move on up the hill. We'll see if that's the right judgment. This is a technically difficult area, and it evolves every day. And so anyone who says they have all the right answers or can, in fact, give us the definition of big data, terrific. Well, thank you very much for your patience. I hope it's been useful. I've enjoyed it. You have had good questions.
Professor, thanks for that. It was incredible to have this opportunity to debate with you about the principles and to reflect a little bit about data protection and privacy. Let me just give you some additional information. So we have 3 publications that we wanted to, if you don't have it already, that you can get here. So we're doing this like a commercial. We're showing the book. So this one is this one's in Portuguese, as Pranesh is showing you. It's a revista do the observatory from Itaú Cultural, debating in Portuguese a lot of issues regarding to internet regulation. Mario in the middle is showing the Understanding Brazilian Internet Bill of Rights. It's a publication of the ITS discussing our own Marco Civil with some articles from our international fellows on specific topics of the Marco Civil. And Diogo is showing you the Carta de Direitos Humanos e Princípios para a Internet, which is a Portuguese translation of the work that our beloved Dynamic Coalition on Internet Rights and Principles has been developing in the United Nations IGF for a long time now. So please do get your copy if you don't have it, like 3 or 4 of them already. And thanks for coming, Professor. Thanks for this wonderful conversation. We have food and we have drinks, so guys, please, house is yours.